Hello, everybody, and a very warm welcome to Stewarts Soundbites. We were just talking before this, Will, weren't we, about how I've lost count of the episodes, so because we've done loads now. But I'm absolutely delighted today to have Will Young here. Will is a barrister at Outer Temple Chambers, and we thought it would be interesting to talk a little bit about the crossover between employment law and catastrophic injury, because Will specialises in both of those areas. And for a lot of people who have sustained catastrophic injuries, the type that we deal with, they're often faced with employment issues because naturally they tend to be employed before an accident, and then afterwards their employment situation generally shifts, whether it's terminated or whether it's adjustments are made. And we'll talk a little bit about how it kind of comes full circle as well, Will, and how a lot of people end up becoming employers themselves. So we thought this would be an interesting topic to cover. As usual, we've got 15 minutes, so it's going to be a whistle-stop tour. So I'm going to dive right in, Will, if that's all right with you.
Yeah, sure, go ahead.
Perfect. So starting with the very basics, I suppose, what are the most common difficulties that people encounter after serious injury in relation to their employment? And can you think of any kind of crucial initial steps that we need to think about?
Yeah, sure. So I think the most obvious question facing people suffering serious or catastrophic injury who are in employment at the time is going to be, how does the injury affect their work, and ultimately can they return to work? And I think that the most important initial step possibly the most important step in general in relation to employment is to keep in communication with the employer insofar as possible. It may not be ultimately possible to return to work, but the best opportunity for doing so is going to be given by keeping the employer informed and keeping lines of communication open, recognizing, of course, that that may not be the first thing on someone's mind after they've suffered a serious catastrophic injury. But I think once the initial things have sort of settled down, I think the best advice is to keep in communication with the employer and keep the employer informed, and that will give them the best chance that they can have of returning to work, possibly in some adjusted or adapted way.
Yeah, and I think that, I don't know whether this is your experience, Will, as well, but I find that employers most of them anyway, tend to be pretty receptive to speaking to family members or case managers, or somebody involved in the early stages anyway. So that's something to bear in mind as well. It doesn't necessarily have to be the client, I guess, if they're not in a position to do that.
No, I think that's right, and I think that employers, their biggest concern is going to be to get information. So I think, generally speaking, I would expect most employers to be receptive to getting information about what the situation is, however that comes to them.
Yeah, sure. Okay. So I suppose the type of clients that we deal with regularly, well, sometimes it's the case that they can't return to their job at all that they had pre-accident, and they may never have any realistic prospect of returning to employment. However, we do have clients who where they're in more of a unique position, I suppose, where despite serious injury, then a return to work isn't completely out of the question in some form. So I mean, I'm thinking about clients who maybe have quite significant physical injuries, but maybe a more subtle brain injury. And in those situations, I wonder, what are the employer's responsibilities in terms of holding a job for someone, in terms of sick pay and leave and things like that?
Sure. So there are a number of issues there. Taking those in sort of reverse order, sick leave. Employees can self-certify for sickness absences of up to 7 days. Obviously, that's not going to be relevant probably in most of these cases. There, technically speaking, you would need a doctor's fit note saying that certifying you as medically unfit to work for absences of more than 7 days. But I think a bit like we were discussing earlier with employers contacting or getting information from case managers or family, I would expect most employers in cases of serious or catastrophic injury to be relatively flexible about the actual provision of sick notes. I think that the issue is much more likely to be about whether the job will be held open long term and about pay. I think that the sort of backstop right is that employees who have more than 2 years service have a right not to be unfairly dismissed, and there are various potentially fair reasons in the statute that gives employees that right. One of the potentially fair reasons is capability, which can include health or medical capability. So it can be a potentially fair reason to dismiss someone if they are medically unable to do the job, but whether or not that is fair in the particular case depends on whether it's reasonable in all the circumstances to take the decision to dismiss someone, and that depends, amongst other things, on the size and resources of the employer and also the particular facts of the case. And that's where medical evidence is likely to be important, because an employer, in order to fairly dismiss someone for medical incapability, will need to satisfy itself that the employee cannot do the job, and probably that there is so little prospect of them being able to do it in future that it's reasonable to terminate their employment for that reason. So employers are entitled to decide that a person cannot return to work, provided that that is a reasonable decision. Generally speaking, some kind of evidence is required, although the nature of the job and the nature of the injury may mean that this is obvious. For, you know, if you've got a very highly physical job and the employee is tetraplegic as a result of the accident, then it may be obvious that they can't do the job, and you may not need to get medical reports that say that. But in most cases, there will be an obligation on the employer to consider alternative employment before taking the decision to dismiss. So that's one of the obligations on the employer, not to unfairly dismiss someone. There are also protections for employees under the Equality Act in terms of disability discrimination. And the definition of disability within the Act is in Section 6, which is that disability is defined as a physical or mental impairment that has a substantial and long-term adverse effect on a person's ability to carry out normal day-to-day activities. In most catastrophic injury cases, well, I'd say probably all catastrophic injury cases, that definition is going to be met, and therefore the person will be a disabled person and therefore will have the protections of the Act. And there are I think two main ones that are going to be relevant in these circumstances. The first is Section 15, which prohibits employers from discriminating against people for a reason that arises in consequence of disability. So, for example, the inability to do a physical job because of disability, there is a prohibition on treating someone unfavorably, which can include dismissing them because of that. But the important thing to bear in mind is that unlike direct disability discrimination, this kind of unfavorable treatment can be justified and hence is not illegal if it's a proportionate means of achieving a legitimate aim, which is essentially a test of reasonableness. So if the employer can say that it's just not reasonable for us to keep employing you because you physically can't do this job, then most employment tribunals are going to say that that's a reasonable justification. So that's one of the protections in the Equality Act. The other significant one is the duty to make reasonable adjustments, which is in Section 20 of the Act. And that says that if a provision, criterion, or practice of an employer, which can really just amount to the requirements of the job, so essentially if the job puts a disabled person at a particular disadvantage compared with someone who is not disabled, then there's a duty on employers to make reasonable adjustments to avoid the disadvantage. And again, the question here is reasonableness. It depends on the extent of the injury, the nature of the job, and potentially whether there are any other alternative roles that an employee could do, because the duty expressly can involve treating a disabled person more favorably than a non-disabled person. So, for example, putting them into an alternative role without requiring them to take part in a competitive interview, that has been held on occasions to be a reasonable adjustment. But it's not an absolute protection, so it doesn't mean that it will always be a breach to dismiss someone rather than transfer them or to make adjustments. But it is a significant protection. It depends on the facts of the case what is reasonable. And I think that, as you said at the outset, there will be cases where the injury is so significant that the person just can't do the job and there are just no alternative roles for them. And I think you and I have both seen a number of cases where the medical evidence is just that this person is unfortunately not going to be able to return to any kind of remunerative employment. But there will be cases where that they could continue in some sort of adjusted role, and that the employer will have an obligation to consider that. And then just finally, the last point you mentioned was sick pay. There's a statutory right to statutory sick pay, but that's low. It's £95.85 per week currently, and it only lasts for 28 weeks. Anything over and above that depends on the contract. It's worth mentioning just one thing, which is that there have been arguments about whether it's a reasonable adjustment to continue to pay someone contractual sick pay indefinitely. Some cases initially suggested that it might be, but the general view now is that that's not a reasonable adjustment to continue to pay someone indefinitely, because the purpose of reasonable adjustments are to get someone back to work. It's not about financially compensating them. It's about getting them back to work, and continuing to pay sick pay indefinitely has been held not to achieve that aim. It's doing something different, really. So that's generally not a reasonable adjustment.
Okay, got you. It's a technical area, isn't it? Well, I mean, it really is, and some of the terms are technical in and of themselves. And I suppose if a person finds himself in a position where it's not straightforward, and then the first port of call for somebody with a claim, I guess, is to say to their solicitor, I need some input on these employment issues, and hopefully the injury solicitor will be able to point them in the right direction. But I guess from your point of view, it's always a good idea to have some sort of legal guidance on these points where it's not straightforward.
Yeah, no, I think that's fair, and I think that I think there are 2 points. Firstly, most catastrophic injury solicitors will either have an employment department at the firm, or at least know someone that they can recommend someone to give them advice, because, as you say, they are slightly different issues, because the legal issues that face someone in their compensation claim are not going to be the same issues that if someone just came to an employment solicitor and said, this is the situation I'm in, can you help me with my employment situation? They're not necessarily the same people who would be advising them. But the other point to bear in mind in relation to the employment situation is that all of these rights that are enshrined in the various legislation, they are there and they are real rights, but the only way you can enforce them, other than by writing solicitors' letters, is by taking someone to the employment tribunal, which obviously can be done and is generally an effective way of enforcing employment rights. But often the situation is best dealt with by just trying to talk to the employer, because obviously the employment tribunal is a last resort, really, isn't it?
Yeah, of course. And I suppose that brings us quite neatly into what I wanted to speak to you about next, which was people that do have personal injury claims after catastrophic injury. Is there anything for people who have come to a settled position, who have those claims, and they come to a settled position in relation to their employment, whether that's termination or whether that's a different role, or in coming to an agreement and forming a contract, I guess, with their employers in that regard? Is there anything for people with claims to bear in mind when they're agreeing certain things with their employers?
Yeah, I mean, I think that it's in one sense it's an obvious point, but any personal injury claim for catastrophic injury is likely to include a claim for loss of earnings. So agreements reached with the person's employer will have a bearing on that. Because obviously if the person is leaving their employment, then that means they're going to have a loss of earnings claim based on the difference between what they were paid before and either nothing if they don't have a residual earning capacity, or some reduced residual earning capacity. But it's worth bearing in mind, I think, that claimants do have a duty to mitigate their losses. So if they are reasonably able to return to work or to find alternative work, they have a duty to try to do that. And if they don't, then the defendant can argue that damages for loss of earnings can be reduced to reflect the failure to mitigate. Again, obviously, a lot will depend on the facts of the case, and in many cases, this is not going to be an issue because it's so clear that the person can't go back to work. And particularly for past loss of earnings this tends to be less of an issue. But in terms of future loss of earnings, claimants do, I think, need to think about the implications of any decision of the kind you're talking about with their employer about whether they go back to let's say a part-time role or an altered role, or whether they leave employment altogether. It is worth thinking about what the implications of that are for the personal injury claim, because it will obviously have a knock-on effect on how much and how easy it is to claim loss of earnings. I mean, I think the flip side of that coin is that that going back to work on a part-time basis or on an altered basis will have an effect on the value of the loss of earnings claim. But in many cases, although it reduces the claim, it's much more important as a positive factor returning to some kind of employment in terms of the structure and benefits that work bring to people who are injured in these circumstances can often significantly outweigh the extent to which it reduces the value of the claim in monetary terms.
Yeah, absolutely. Yeah. And I was gonna press a little bit more about reasonable adjustment point, because I find that really interesting actually in practice. But we're running out of time, so I'm going to run by it and ask you a little bit about. I mean, employment issues are obviously affect the person who's been injured hugely, but it can also affect carers, loved ones, other halves who are also working, and it can affect their employment if they suddenly find themselves in a caring role. And is there any provision for those people in terms of time off or any help in their own employment situations?
So I think this is more difficult because there's currently no legal right to paid time off to care for a loved one. There is an EU directive which covers paid time off to care for parents, children, or spouses with serious medical issues, and I think it's 5 days per year, but that's not enacted in UK law and is now unlikely to be enacted, I would have thought, given Brexit, at least in the form of the directive. There was a consultation opened by the UK government in March 2020 about right to paid carers leave. I think that consultation closed in August 2020, but I'm not aware of any indication as to when and in what form that would become law. There is some protection in the Equality Act from associative discrimination, so discrimination against someone because of someone else's disability, but it's only direct discrimination, so it wouldn't cover, for example, someone being discriminated against because they've taken time off to care for someone. So there are other arguments that a loved one or a spouse or family member of someone who is seriously injured could make in relation to being treated badly by their employer because of the time they take off for caring. But it would have to be about arguments about the implied terms of their contract and things like that. And as I said, in relation to the employment tribunal, ultimately, the only solid way you've got of enforcing that is of resigning and claiming constructive dismissal, which is quite an extreme step. And understandably, most people are reluctant to do that if they get into a dispute with their employer. So, I mean, there are arguments you can make about the implied term of trust and confidence, and you can certainly make those arguments to your employer in an attempt to make them behave more reasonably if you have caring responsibilities. But I do accept that it is often a very difficult situation to find yourself in, and I'm afraid that there aren't any brilliantly obvious answers to that.
Yeah, as is often the case with all of this stuff, well, it's never straightforward. We never offer any black and white solutions. And we're already a wee bit over time, but I think the last one is just really important to cover off very, very briefly, which I touched on at the very beginning and talked about how sometimes people with catastrophic injuries find themselves becoming employers themselves. So for instance, clients with high-level spinal cord injuries where they have, a directly employed care package in place. And could you maybe just tell us a little bit about that?
Yeah, sure. So I think most of what we've talked about is about the injured person themselves being employees, and that is the scenario in which employment law is most likely to rear its head in a catastrophic injury case. But of course, you're right. An injured person who has a care regime in place may end up being the direct employer of the carers, and even if they're not, even if it's agency care, they will be the end user for the carer who is employed by the agency. So these issues may be faced by an injured person from both sides of the argument. Now, with directly employed carers, the case manager will probably deal with most of the employment issues, but the injured person does need to bear in mind that there will be obligations on them, for example, about non-discrimination against carers who are employed. And as I say, anyone with a case manager will be able to get some assistance from them on that. But it is just worth, I think, bearing in mind that the injured person may well be the employer as well as an employee.
Yeah, and it's worth you know, I suppose it's a useful practice point for case managers to have that discussion with clients in deciding how their care package is going to be set up, and helping them understand that. So that's really useful. Well, thank you ever so much. And as always, we've run out of time, which I'm gutted about every week. But I thank you very, very much.
No, thank you for having me.
No, it's a pleasure, and maybe we'll rope you in to do a part 2. We'll be able to cover some stuff in more detail. If anybody has any questions arising from any of the issues that we've talked about today, and you do want a bit more information on any of them, feel free to drop me an email, and we'll put the email address for the Outer Temple team on the end of the slide as well. So do get in touch if you've any questions, and we'll look forward to seeing you again soon. Thank you very much.
Thanks.